Hi folks, I'm attorney Richard LaGarde, and I'm back with part 6 of our 7-part series of tips on how to give a great deposition. These are tips I've given my own clients over the past 30 years. Because each deposition and each case is different, it's important that you talk with your own attorney before you give your deposition. Now, if you're ready, let's get started. Here's tip 51. Watch out for questions that assume facts that aren't true. Lots of times attorneys will ask a question and they'll throw in a statement meant to be a fact that might be helpful to their case, but it isn't a truthful statement. If you catch an attorney saying something that's not true, assuming something is a fact that is not a fact, stop them and tell them, wait a minute, that's not accurate. Here's tip 52. Don't let the attorney limit your choices. What do I mean by that? Lots of times attorneys will ask a question. They'll say, now sir, was it A or was it B? Well, if it wasn't either A or B, tell the attorney it wasn't either, it was C. See, lawyers will sometimes give you false choices. They'll give you a choice between one option and another, neither of which is true, and don't let them do that to you. Here's tip 53. Don't let the attorney improperly summarize your testimony. What do I mean by that? Lots of times attorneys will say, now sir, you testified earlier that it was A and B. Now if you didn't say that, stop the attorney and say, wait a minute, that's not right. I didn't say it was A and B, I said it was C. Here's tip 54. Beware of absolutes like always and never. Attorneys will sometimes ask you questions like, have you ever done this? Or did you always do that? And if you agree with him or her, then now you've testified to something that might not be absolutely true. So never use the word always. Never use the word never unless you're absolutely sure that that's 100% truthful. Here's tip 55. Remember that nothing is off the record. Lots of times attorneys will try to chat with you during breaks informally. First of all, your attorney shouldn't allow that to happen. But if that does occur, don't assume that you can chit-chat with the other attorney and that anything you say is off the record just because the video camera is not rolling and the court reporter's not sitting there taking down your testimony. And here's why. There's nothing to stop that attorney from walking into the deposition when it resumes and to ask you that very same question. So remember, nothing is off the record. Here's tip 56. Look out for the "is that all" question. Attorneys will often ask you questions like, tell us all of the ways that this injury has affected your life. And then they'll stop and say at the end, is that all? And as a witness, if you say yes, you're now limiting yourself, because if at trial you remember something else that has happened, you remember some other way your injury has affected your life, you've already testified that's all. So when you're questioned about that, when you're asked, is that all? It's best to say, that's all I can remember right now. That's all I can recall at this point in time. That gives you the option, if you do remember something later, to add it to the list. Here's tip 57. It's okay to say that you met with your attorney before the deposition. You'll probably be asked by the other attorney, have you had a chance to meet with your attorney before your deposition? It's okay to say yes. What's not okay is to tell him what you and your attorney spoke about. That's called attorney-client privilege information, and the other side's not entitled to know that. But they are entitled to know if you met with your attorney before your deposition. Here's Depo tip 58. It's okay to say that your attorney explained what a deposition's all about. Just don't discuss the details of your conversation. Here's tip 59. Don't bring documents to your deposition unless your attorney tells you to do so. I'll give you an example. I had a client once who, during the course of her deposition, said she didn't know the answer to her question, but she could look it up on the documents in her car. Well, what do you think happened? The other attorney said, well, let's take a break, go down to your car and bring those documents up here so we can go through them. And what should have been a short deposition took 3 or 4 hours as every piece of paper was gone through by the other attorney. So again, don't bring documents to a deposition unless your attorney tells you to do so. Here's tip 60. If you're asked about a document, take the time to fully read the document before you answer the questions. A lot of times attorneys will ask you a question about a document and you may not have a full memory of what's in that document. Take the time to read it fully before you answer the questions. Don't worry, the attorneys can just wait until you've had a chance to fully read it. Well, folks, that's it for now. More tips on how to give a great deposition are available at our website. We'll see you back next time at part 7 of our 7-part series on how to give a great deposition. Thanks for watching.